Hello everybody, how's Psych and Law today? Got a short one for you, and there's actually no assignments associated with this one. I think in spite of that, it's a hugely important lecture to consider what's available to us in the future. And I know many of you want to, in some way, shape, or form, become agents of change. And for many of you, the legal system seems like an important domain to become an agent of change. So I want to talk here some examples about alternatives to traditional prosecution and alternatives to settling disputes. So that's what we're about here. Now let's just move into it. It's a brief lecture in two parts, right? Alternative models to traditional prosecutions, and then the Intercept model of intervention. So we're going to start off kind of on the light end of it, whereas we talk about alternative dispute resolution. And we know that in civil court, we enjoin someone in a lawsuit because we feel they've somehow damaged us or aggrieved us. They didn't supply what they promised. So in civil court, the plaintiff sues the defendant on the basis of some perceived unfairness, some violation of the law, some failure to adhere to contractual obligations, if you will. Now, the idea was, though, that this can be really expensive and really time-consuming. That is, we take someone to court, we may have a trial by judge, as we described in civil awards earlier, about the consistency between trial by judge and trial by jury, etc. Or we can choose some less expensive method to do this, something that occurs in a more rapid time frame. And examples of this is arbitration or summary jury trial, mediation. All of these allow us to settle our disputes in a less formal, less time-consuming, and less expensive manner. So they can be applied to both civil and criminal cases, but the focus would probably be in civil cases to a greater extent. What's the benefit, though? Well, we can reduce the number of cases going to court, right? So we see that in civil cases, 11.5% in 1962 has been reduced to 1.9% in 2009. And we see a significant reduction, even more, in criminal cases. Well, there's greater pressure from the courts to settle, to not go to these full-blown jury trials that are so expensive and so time-consuming. Ultimately, we save costs, we save attorney's fees, we save expert witness fees. There's a huge amount of money to be saved. So alternative dispute resolution can be negotiations, such as are seen with labor contracts, let's say between a company and a union. When I was at Columbus State, right, teachers had a union, and we would negotiate salaries, benefits, responsibilities every 3 years. And it's our union representatives who would sit down and negotiate with representatives from the college and come to some kind of binding solution that is a new contract. Personal injury. So we know that I may in fact have been injured in a car accident and I seek damages from the other driver or their insurance company. Divorce, collaborative divorce negotiations. That is, rather than go through a lengthy, costly process, we then find simpler ways to resolve the dispute. Now, arbitration is closest to a trial. It can increase. It can create binding agreements. So in this case, we both agree to have our case heard by an arbitrator, someone who's trained to listen, and we agree that their decision will be binding, right? In this case, we do provide evidence, so it is somewhat like a trial, but less full-blown. And then summary jury trial, as evidence is presented by attorneys, instructions are given by a judge, the jury advises, but it's done in a much lower key fashion, so it can save time, right? So all of these then, including mediation and common to all, what do we know? General perception of fairness, as long as one believes they were heard and understood. And remember that we get back to what is the trial for? To provide a perception, to provide a sense that justice has been done. So, for example, with mediation, the mediator is a facilitator, and it's also known as shuttle diplomacy. So my wife sometimes volunteers in conjunction with an attorney, she's a paralegal, to engage in these evening mediation cases. And instead of going to trial, people agree to have a mediator listen and then describe one party's position to the other party and go back and forth describing points of view until hopefully both sides then can find a common ground for the resolution. People believe if they've been listened to, that often they've been heard, and therefore decisions are made more fairly. Generally favorable reaction tied to these processes because it enhances someone's feelings, their perception of personal control. Risk aversion feeds into this, the parties deciding fate rather than leaving it in the hands of unknown others. So sometimes people don't like to engage in this to the extent that they feel the process is out of or beyond their control. Okay, so that was part one as promised, and this is a short one. Now we're going to go to part two, the sequential intercept model. Let us think and reimagine the justice system in the way it operates, in the way it interacts with all those parties involved in the legal system. Remember, that goes all the way back to the beginning of the course when I asked that question, who is part of the legal process? This describes 5 stages of the criminal justice system where we might make interruptions, and that's why it's called an intercept model, right? To substitute a community treatment alternative. So rather than just effect an arrest, go to court, and place someone on punishment, right, or not, can we be creative? Can we be imaginative? Can we intervene at non-traditional areas of the process and hopefully create solutions that are more effective, they're more efficient, they cost less, and support our notion of justice being done? Now, one of the first places to concentrate then is law enforcement, right? We might then develop specialized law enforcement responding units. That is, if we get a call where it appears that the person who's causing the problem, right, is suffering some kind of psychological disturbance, then wouldn't it be nice if we could intercept at that moment in time rather than just send out rank-and-file police officers who have little knowledge of how to deal with the mentally ill? If we could send someone who has the capacity, the training, the experience to deal with people who are mentally ill. So these specialized police responding crisis intervention teams can be developed for different types of audiences, right? Different types of people with whom they need to interact. They're more likely to get help, get people to the help of mental health services. They're less likely to use force or escalate the situation. In concert with this, then, we typically find less harm, ironically, to the first responders, and we see an overall reduction in costs. This also then creates a nice occupational benefit, because what we can do with police departments, if we're creative, said, hey, are you willing to take on additional training? Are you willing to take on this training that qualifies you to be part of a crisis intervention team? And if so, then are you willing to take this training, invest your time and energy, and perhaps then we'll give you a slight pay increase for participating on these crisis intervention teams. So police officers have the opportunity to move simply from patrol officer rank and file to patrol officer with an additional crisis intervention qualification. And note, that's good for the police officers because they develop a sense of accomplishment. They broaden their repertoire, their resume, so to speak. And it serves the public to a greater extent because now we may be talking people off the ledge rather than beating them off the ledge, if you will allow that analogy. Now, another place that we might develop creative solutions to problems is post-arrest. That is, someone's been arrested, sure, the initial detention, hearing, pretrial services, and remember, we appear before a judge, or before we get to the judge, it might identify, right, that this person, this category of person, might benefit from treatment rather than pushing them through the typical judicial process. So we might then send people to treatment or assign specialized probation. Let's face it, putting people who have a substance abuse problem in prison rarely does any good. And we've learned this over time. We see the recidivism, right? Punish that drug user, and that'll show them. No, what they probably need to do is get into treatment, and we can avoid the whole expensive prison in the first place, right? So, initial research shows some positive outcomes. Correlational research has its shortcomings. There's no random assignment. Quasi-experiments sometimes applied to address this. And do you remember the one quasi-experiment we talked about? Way back when we were in the police lecture, when we talked about random assignment of domestic abuse responses, right? So we might in fact do the same to illuminate the effectiveness of these programs, right? Perceived positive outcomes: people get to spend more time in community, they're not detached from the community, fewer subsequent arrests, and hopefully less homelessness as a result of these processes. Now, the sequential intercept model, this is at the third step, intercept number 3, right? This is the most recognized, and this is where we go to court, right? We have problem-solving courts. So someone appears before a judge and they're remanded to a problem-solving court. And this helps the individual cope with chronic adjustment problems to reduce recidivism. And these courts are expanding just amazingly. So you can have homeless courts. If someone's, you know, continually being brought in touch with law enforcement as a result of features growing out of their homelessness, then what can we do? Can we have special courts where we divert these people to address the issues that are supporting, maintaining, right, creating their homelessness as part of it? Or maybe it's a drug court, right? Or maybe it's a family court that deals specifically with domestic violence. But these are courts that are tailored to a specific subset of human problems. So it hasn't abandoned conventional jurisprudence techniques, but it's modifying them, right? So immediate intervention and treatments could be the result of this, not jail time. Greater monitoring by the courts, right? And this becomes less adversarial and more cooperative in nature. Compliance often rewarded by sentence reduction or sentence elimination. Now, we could have drug courts, we could have mental health courts, we can have homeless courts, we can have domestic violence courts, we can have community courts, and interestingly, veterans often suffer a subset of problems that's not maybe seen in other subpopulations. And this might have to do with PTSD, among other issues that veterans experience. So by diverting, let's say a vet has been unable to deal with their experience, and they develop alcoholism as a compensatory feature, and under the effects of alcohol they tend to become violent, let's say. Well, the violence is what causes them to be arrested. But notice that it's the experience and the lack of resolution in their activities as a veteran that led to the... So let's address the underlying causes, and that's a big opportunity of these courts and these systems. Okay? Now, intercept number 4 is transition from incarceration to return to the community, and this is often represented by halfway houses. So rather than just take someone to the prison gate, you know, hand them 20 bucks, put them in a new suit or whatever's done, and then kick them out in the community, you might develop work programs or halfway houses or some combination of both to facilitate the reintegration of the former offender into society. And then while on parole, following release from incarceration, treatment might be required. Right? So will the trend continue? And I leave that to you to consider. And then why or why not do you think it might continue, or why do you think it might be abandoned? But it's a chance to employ our creativity. It's a chance to more stringently, empirically test these interventions. And there's a lot of room for psychologists to participate in almost all of these intercept points. And let's hope that maybe that gets done. Now, a couple quick reflections, and this gets back to this idea in our course of needs assessment, program design, and program evaluation. And note that this lecture is like totally, is there a need? Well, yeah, it appears there's a need. What is the program we're going to use? And then finally, can we evaluate the success, the efficacy of the program, right? What needs to be done to understand whether the programs are being successful or not? What negative consequences, and this is just a boilerplate question at this time, what negative consequences might occur as a result of these newfangled ideas and these newfangled processes? What are the pros? Yeah, we clearly can identify the potential pros because that's built into the program. That's why we're doing it. But what are the possible cons? And then how do the first, second, third, and finally the fourth dilemmas apply to the understanding of these issues? And note that those dilemmas are the core aspects of this course, so we can always return to and trying to understand what's going on, looking at it in terms of the dilemmas. And then finally, does the adoption of these programs demonstrate a shift away from the crime control model to the due process model, or not? Or both, or neither, remember? Because anytime someone says, hey, is it this or that, we ought to be ready to pull out of our pocket, hey, you're asking me, is it this or that? I'm going to offer you that it's possible that it's both or neither as well. So the four possible outcomes of that. Regardless, that's just a brief look at what's possible, what's being done as well, and what's possible as a result of it. So let's call it good. I hope you guys have a good day, and get ready because Lecture 10 will be the next lecture up. Yeah, 10 follows 9, and it'll be a biggie. So the only thing that's preventing me from recording it so far is I've got to, over the next day or two, come to some kind of committed conclusion on what our assignment will be to support Lecture 10, Forensic Psychology in Criminal Cases. So have a good day, guys.